morning, everyone. I'm here to discuss this lesson for today. What is intellectual property? Presented by, that's me, Perez Christian Silverio. From the CPE 32, I'm from also in Group 2. The title and content. The first title is the introduction from the definition of intellectual property. Topic 1 is the copyright law. Topic 2 is the patent law. Topic 3 is the trade secret law. And lastly, the trademark law in topic 4. Introduction. What is intellectual property? Intellectual property or IP refers to creation of mind such as inventions, literary and artistic works, designs, and symbols, names, and images used in commerce. IP is protected in law by, for example, patents, copyright, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. By striking the right balance between the interests of innovators and the wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish. Ang intellectual property ay nagbibigay proteksyon sa bawat tao sa kanyang gawang kaisipan para maprotektan ito sa mga copyright infringement, mga pangongopya, mga plagiarism, or another illegal acts to protect their artistic works, mga gawa, mga sarili nilang idea na para hindi lumabas sa ibang tao, kopyahin at palabasin na sila ang unang gumawa nun. Ito ay base din sa pagkakaroon ng balancing pabor sa ibang tao at sa taong gumawa ng kanyang ideya na yon o kanyang inimbentong isang bagay. Para walang magkaroon ng lamangan, dayaan, or kopyahan na siyang gawain ng intellectual property. Topic 1. What is copyright law? Copyright or author's right is a legal term used to describe the rights that creators have over their literary and artistic works. Works covered by copyright range from books, mga libro, music, mga kanta, paintings, mga drawings, sculptures, mga nililok, at mga pelikula o mga films to computer programs, databases, advertisements, maps, and technical drawings. Topic 2. What is patent law? A patent is an exclusive rights granted for an invention, which is a product or a process that provides, in general, a new way of doing something or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. Ang patent, kadalasan nangyayari yan sa mga research institutes or mga science laboratories or mga kahit anong kinalaman dun sa mga inventions, mga invention ng tao para maprotektahan ang kanilang gawa dun sa mga gagaya ng kanilang invention. For example, may isang aeronautics engineer na gumawa ng silat dun sa aeroplano so that kailangan niya ng patent para maprotektahan ang kanyang gawa at hindi ito magaya ng ibang bansa at ma-discredit ang kanyang gawa. The patent versus copyright. The patent is patents protection inventions such as new machinery, processes, chemicals, and design of manufactured objects. Katulad yan ng mga gamot, mga sasakyan, mga cellphone. Need yan ang patent. While the copyrights protection original creation such as musical compositions, mga awitin, tula, poetry, mga arts, mga pelikula, films, computer software, and website content. Ang patent is inventions must be new. Hindi siya yung luma, kailangan bago, useful, and non-obvious. While the copyright is must be original and creative work. Patent is inventors must go through a registration process. While the copyright is no registration process, it's automatic. The patent is provides protection for 20 years and registration must be renewed. Kailangan nila mag-renew na lisensya nila sa patent for 20 years para sa kanilang produksyon, para sa kanilang protection, while the copyright is provides protection for a long time, habang buhay na po yan, hanggang sa mamatay ang gumawa. Topic 3. What is trade secret law? Trade secrets are intellectual property or IP rights on confidential information which may be sold or licensed. What qualifies as a trade secret? Ano nga ba ang mga kwalifikasyon? In general, to qualify as a trade secret, the information must be commercially valuable because it is secret. Mahalagang mahalaga ang isang bagay para ito ay itago ng isang organisasyon. Be known only in a limited group of persons, mga staff lang ng isang organisasyon, ng isang empleyado, or kahit sino mas pinagkakatiwalang tao ang makakaalam lang ng isang trade secret. At panghuli ay be subject to a reasonable steps taken by the rightful holders of the information to keep it secret, including the use of confidentiality agreements for business partners and employees. Dapat magkaroon ng isang dahilan na para magkaroon ng isang sikreto na mahalaga. Kailangan magkaroon ang bawat isa o ang dalawang parties ng confidentiality agreements para magkaroon ng kasunduan na at panunumpa na hindi nila ilalabas ang trade secret na yan. dahil dyan sa confidentiality agreement. The unauthorized acquisition, use, or disclose of such secret information in a manner contrary to honest commercial practices by others is regarded as an unfair practice and a violation of the trade secret protection. Ang pag-leak o paglalabas ng kahit anumang secret information ay itinuturing ito ay isang unfair practices at paglabag sa trade secret protection. Last topic is the topic 4. What is trademark law? A trademark is a sign capable of distinguishing the goods or services of one enterprise from those of other enterprise. Trademarks are protected by intellectual property rights. Ang trademark ay nakikita kadalasan sa mga restaurants, sa mga photography services, basta may kinalaman sa services, food and services, business services, and so much more na pinaprotektahan nila ito sa isang produkto at serbisyo na kanilang nilalabas. That's all. Yan na po ay yung text and references na makikita sa ating screen. That's all for today. And thanks sa panonood. And thanks din po kay Sir Jonathan Marano. Bye.
Key intellectual property issue. Key intellectual property issue. The first one is copyrights. Do you know what is copyright is? It is about author's right, or a legal term used to describe the rights that creators have over their literary and artistic works. The works covered by copyright range from books or music, even in painting, sculpture, and films, to computer program, databases, advertisement, maps, and technical drawings. This grants creator of original works the exclusive right to: first is to distribute, to display, perform, reproduce, work, and prepare derivative works based upon the work. Sani Bono Copyright Terms Extension Act, created after January 1, 1978. It is the life author plus 70 years. It was created but not published or registered before that year. It created in before 1978, still in original or renewable term of copyright, 95 years from the date the copyright was originally secured. This is the type, or these are the type of work that can be copyright. Like what I've said earlier, it is architecture, even art, audiovisual works, choreography, drama, graphics, literature, or even in motion pictures. These things also can be copyrighted. The music, pantomimes, pictures, sculptures, and sound recordings. Copyright infringement, it is a copy substantial and material part of another's copyrighted work, or using it without permission. Also, copyright infringement, it is the use or production of copyright protected material without the permission of the copyright holder. Um, Copyright infringement means that the rights afforded to the copywriter, to the copyright holder, such as the exclusive use of work for a set period of time, are being breached by a third party. Software copyright protection, ensuring that no one will copy your software and use it illegally. In theory, the software is protected under the copyright law as soon as the code is fixed in a tangible medium. So the law provides a sort of automatic software copyright protection. Yes, that is software copyright protection. It is the enforcement and substantially increased penalties for infringement. It is the law prioritizing resources and organization for intellectual property, or PROIP. It is the Act of 2008. There is a General Agreement on Tariffs and Trade, or GATT. These are trade agreement between 117 countries, and it created the World Trade Organization to enforce, and despite GATT, copyright protection varies greatly for country to country. The WTO and the WTO TRIPS Agreement in 1994 are the trade-related aspect of intellectual property rights. Many nations recognize the intellectual property has become increasingly important in the world trade. It established minimum levels of protection that each government must provide to be intellectual property of members. It covers copyright, patents, and also the trade secrets. The World Intellectual Property Organization, or WIPO, it is agency of the United Nations that advocates for interest of intellectual property owners. And WIPO Copyright Treaty provides additional copyright protection for electronic media. Digital Millennium Copyright Act, or DMCA. Civil and criminal penalties are included. It governs distribution of tools and software that can be used to circumvent technological measures used to protection copyrighted works. It also provides safe harbors for ISPs whose customer subscribers may be breaking copyright laws. ISP must comply with notice and takedown procedures that grant copyright holders a process to halt access to allegedly infringing content. The next one is patent. A patent is a type of intellectual property that gives its owner the legal right to exclude others from making, using, or selling an invention for a limited period of time in exchange for publishing and enabling disclosure of the invention. Also, the patents are used to protect the way things work. A patent is a right granted for an invention that is new and useful. It is a registered patent provides the owner of the invention with the exclusive right to exploit it commercially for the life of the patent. Um, it was issued by the U.S. Patent and Trademark Office, or USPTO. It permits an owner to exclude the public from making, using, or selling the protected inventions, but allows legal action against violators. The applicant must file with the USPTO, or the USPTO search prior art, and takes an average of 35.3 months from filing an application until application is issued as a patent or abandoned. The prior art of this was existing body of knowledge available to a person of ordinary skill in the art. An invention must pass for test. It must be in one of the 5 statutory classes of items. Must be useful, must be novel, must not be obvious to a person having ordinary skill in the same field. Items cannot be patented if they are: first one is abstract ideas, laws of nature, or even natural phenomena. The patent infringement, making unauthorized use of another patent, has no specific limit to the monetary penalty. The software patent, it's protect feature, function, or process embodied in instructions executed on a computer. Also, a software patent is a property right that protects computer programs or any performance of a computer from computer programs. It is a software patent is considered a type of utility patent with no true legal definition. Software patents are a topic of controversy both in United States and around the world. Did you know that 20,000 software-related patents per year have been issued since the early of 1980s? Some experts think the number of software patents being granted inhibits new software development. Before obtaining the software patent, do a patent search. Software Patent Institute is building a database of information, and it's also software cross licensing agreements. A large software companies agree not to sue each other over patent infringement, and other small businesses have no choice but to license patents if they use them. The average patent lawsuit cost $3 to $10 million. It also a defensive publishing. The alternative to filing for patents, company publishes description of the innovation, establish the idea's legal existence as prior art, cost mere hundreds of dollars, no lawyers, and fast. Patent troll firm. It acquires patents with no intention of manufacturing anything, instead licensing the patents to others. A patent troll is a company that owns the intellectual property or IP for products and services that it doesn't actually provide. Instead, it monetizes the IP by using companies for infringement upon its patents, claiming a violation of an intellectual property right. Standard is a definition or format. It was approved by recognized standards organization or accepted as a de facto standard by the industry. Also, it enables hardware and software from different manufacturers to work together. The next one is submarine patent. Patent or process invention hidden with a standard. It also does not surface until standard is broadly adopted. A submarine patent is a patent whose issuance and publication are intentionally delayed by the application for a long time, which can be several years or even a decade. The patent farming involves influencing a standards organization to make use of a patent item without revealing the existence of the patent, demanding royalties from all parties that use the standard. And if you ask what is the difference between the copyrights and patent, the copyright is an automatic right which protects originally literary, dramatic, musical, and artistic works, while a patent is a registered rights that gives the owner exclusive right to features and process of inventions. So that's all. Thank you.
Intellectual property, trade secrets, and employee trade secrets. Trade secret. Trade secret is a business information. It represents something of economic value. It requires an effort or cost to develop, some degree of uniqueness or novelty, generally unknown to public, and kept confidential. In trade secret, information is only considered a trade secret if the company takes steps to protect it. Trade secret law has a few advantages over patents and copyrights. Advantages is no time limitation, no need to file an application, patents can be ruled invalid by courts, no filing or application fees. The trade secret law doesn't prevent someone from using the same idea if it is developed independently. Trade secret law varies greatly from country to country. UTSA or Uniform Trade Secret Act established uniformly across the state in the area of trade secret law. computer hardware and software can qualify for trade secret protection. The Economic Espionage Act of 1996 penalties up to 10 million and 15 years in prison for theft of trade secrets. Example of trade secrets includes marketing plans, formula for composition, and manufacturing process. Employees and trade secret. Employees are the greatest threat to trade secret. Unauthorized use of employees' customer list. Customer list is not automatically considered a trade secret. Educate workers about confidentiality of lists. Non-disclosure clauses in employees' contract. Non-complete agreement prohibits an employee from working for any competitors for a period of time. Protect intellectual property for being used by competitors when key employee leaves. Require employees not to work for competitors for a period of time. Wide range of treatment on non-complete agreements among the various states.
Plagiarism means using someone else's words or ideas without properly crediting the original author. Some common examples of plagiarism include paraphrasing a source too closely, including a direct quote without quotation marks, copying elements of different sources and pasting them into a new document, leaving out an in-text citation, and submitting a full text that is not your own. Plagiarism of intellectual property is when you pass another person's ideas or work off as your own. And why don't many students understand plagiarism? It is simply because they were never taught citation, cut between instructors who thought it was too early or too late to teach citation. They never really learned the art and never had its importance impressed upon them. Public domain works are freely available for use without restriction, but no one can ever own it. An important wrinkle to understand about public domain material is that while each work belongs to the public, collections of public domain works may be protected by copyright. Fair use allows limited use of copyrighted material without permission from the copyright holder for purposes such as criticism, parody, news reporting, research, and scholarship and teaching. Nowadays, where everything is digitalized, it can be hard not to plagiarize. We are taking in so much information every day that influences our views and ideas. But that's not any excuse for the behavior of stealing from someone else. Unintentional and light-hearted copying is still plagiarism. That's one of the things you should be learning from university. You can pass off someone else's ideas or research as your own. If you have graduated and still don't understand that basic fact, I'm not sure what you actually learned. Plagiarism is a serious offense from an university standpoint. It could have extreme negative implications on your academic career. There are different types of plagiarism. First, complete plagiarism. It is the most severe form of plagiarism, where a researcher takes a manuscript or study that someone else created and submits it under his or her name. It is equivalent to intellectual theft and stealing. Source-based plagiarism. Plagiarism may occur because of the different types of sources. For example, when a researcher references a source that is incorrect or does not exist, it is a misleading citation. Plagiarism also occurs when a researcher uses a secondary source of data, or information, but only cites the primary source of information. And third is the direct plagiarism. Direct or verbatim plagiarism occurs when an author copies the text of another author word for word without the use of quotation marks or attribution, thus passing it as his or her own. And fourth, self or auto-plagiarism. Auto-plagiarism, also known as self-plagiarism or duplication, happens when an author reuses significant portions of his or her previously published work without attribution. Paraphrasing plagiarism. This is, as published on Wiley, the most common type of plagiarism. It involves the use of someone else's writing with some minor changes in the sentences and using it as one's own. Even if the words differ, the original idea remains the same and plagiarism occurs. Inaccurate authorship. Inaccurate authorship or misleading attribution can happen in two ways. First, in one form, when an individual contributes to a manuscript but doesn't get credit for it. The second form is the opposite, when an individual gets credit without contributing to the work. Mosaic plagiarism. It may be more difficult to detect because it interlays someone else's phrases or text within its own research. It is also known as patchwork plagiarism, and it is intentional and dishonest. Accidental plagiarism. Whether intended or unintended, there is no excuse for plagiarism, and the consequences are often the same. However, plagiarism may be accidental if it occurred because of neglect, mistake, or unintentional paraphrasing. Students are likely to commit accidental plagiarism, so universities should stress on the importance of education about this form of plagiarism. Plagiarism detection system can be developed for text data such as essays, articles, journals, research, and so forth. A more structured text documents such as programming languages. Modifications are usually done by students of programming can be classified as follows. First is lexical. Changes in the code program, for example, changing comment, changing format, changing variable name. Second is structural. Changing program structure, for example, uh, change the order of the algorithm doesn't change program course. Change the procedure becomes a function or vice versa. The procedure is replaced with the contents of the procedure itself. The benefit of plagiarism detection system is to aid the detection of the manual in making comparisons between the amounts of source code in a short time. Major aspects of development that must be considered in plagiarism detection system is suitable discriminator to indicate the presence of plagiarism. Make a suitable method for comparing these discriminators and appropriate measurement of similarity. It allows those who are reading your work to locate your sources in order to learn more about the ideas that you include in your paper. Citing your sources consistently and accurately helps you avoid committing plagiarism in your writing. Teach them to use the most common citation style, such as MLA style in the humanities, APA style in the social science, Chicago Notes and Bibliography in history, Chicago Author Day in the sciences. Schedule major writing assignments in portions due over the courses of the term. Tell students that instructors are aware of internet paper mills and plagiarism detection services. Incorporate detection into anti-plagiarism program. Reverse engineering is the act of dismantling an object to see how it works. It is done primarily to analyze and gain knowledge about the way something works, but often is used to duplicate or enhance the object. Reverse engineering is a precise form of product teardown that can be the basis for many intellectual property cases. The process can be applied to products, systems, or components, from mechanical assemblies to biological, chemical, and organic matter. In IP, the legality of the reverse engineering process is a frequently debated subject. Non-disclosure agreements, end-user license agreements, and anti-circumvention can act as legal barriers to reverse engineering. Some laws, like the Digital Millennium Copyright Act, plays a vital role in legally allowing software reverse engineering to occur. The purpose of reverse engineering is to find out how an object or system works. There are a variety of reasons to do this. Reverse engineering can be used to learn how something works and to recreate the object or to create a similar object with added enhancements. There are several instances where reverse engineering is used to disassemble software. A common example is to adapt a program written for use with one microprocessor to another. Other examples include reconstructing lost source code, studying how a program performs certain operations, improving performance and fixing bugs, or correcting errors when the source code is not available. One example is Phoenix, a US software company that created Basic Input-Output System or BIOS software, which was compatible with IBM's proprietary version. To do this, Phoenix reverse engineered the IBM version in a way that protected them from copyright charges by recording the steps it followed and not referencing the proprietary code. Malware is another area where software reverse engineering is used. Threat actors often use software code obfuscation to keep their malicious code from being discovered or understood. The owners of infected software or systems can use reverse engineering to identify malicious content, such as a virus. If a processor manufacturer wants to see how a competitor's processor works, it can buy a competitor's processor, reverse engineer it, and then use what it learns to make its own processor. This process is illegal in many countries, and it requires a great deal of expertise and expensive. Reverse engineering is often used to create replacement parts when the original parts for legacy equipment are no longer available. Reverse engineering of computer parts is also done to enhance security. For example, Google's Project Zero identified vulnerabilities in microprocessors using reverse engineering. In order to perform reverse engineering, you need to combine skills in disassembling, network monitoring, debugging, API integration, several program languages, compilers, etc. You also have to be very careful when reversing software in order not to break copyright laws or harm your system. Database reverse engineering is the process through which the logical and conceptual schemas of a legacy database or of a set of files are reconstructed from various information sources such as DDL code, data dictionary contents, database contents, or the source code of application programs that use the database. A compiler takes the program code and converts the source code to a machine language module called an object file. You can reverse engineer any program The result will not be the original source code with comments, descriptive variable names, structure, etc., but its functionality will be the same. The language processor that reads the complete source program written in high-level language as a whole in one go and translates it into an equivalent program in machine language is called a compiler. And the example of it is C, C++, C Sharp, and Java. Software reverse engineering is a process of recovering the design, requirements, specifications, and functions of a product from an analysis of its code. It builds a program database and generates information from this. Reverse engineering in manufacturing and engineering is used to find out how equipment or products are made and work. A type of reverse engineering, a decompiler, performs the opposite operations of a compiler. It converts executable program code into a human understandable form. Is it legal to decompile code? Decompilation is sometimes used unethically without the permission of the copyright holder to reproduce source code for reuse or adaptation. The decompilation of copyrighted software is illegal in many countries, although the specifics differ from country to country. In the US, for example, copyright laws don't fully restrict decompilation. The Digital Millennium Copyright Act, or DMCA, allows reverse engineering. If a person has lawfully obtained a right to use a copy of a computer program only to identify and analyze its elements to achieve interoperability with other programs. New court cases reveal that reverse engineering practices which are used to achieve interoperability with an independently created computer program are legal and ethical. Interoperability has been defined as the ability of computer programs to exchange information and of such programs mutually to use the information which has been exchanged. Achieving interoperability through reverse engineering can infringe the rights of the original owner. One of the main motives for reverse engineering software is to enable new software products to interact with programs that are already available. Courts have recognized that reverse engineering is important for public benefit and to encourage inventors and businesses, thereby maintaining healthy competition in the market. Because reverse engineering can be used to reconstruct source code, it walks a fine line in intellectual property law. Many software license agreements strictly forbid reverse engineering. Software companies fear that their trade secret algorithms and methods will be more directly revealed through reverse engineering than they are taught external machine observation. However, there is no general purpose law against reverse engineering. Many companies consider reverse engineering an unethical practice as it enables others to violate their copyrights and steal their intellectual property. However, many others state that back engineering is not illegal, thus it is not unethical either. The benefits of reverse engineering are plenty, as long as it is used appropriately. Right to reverse engineer under the Fair Use Doctrine and Digital Millennium Copyright Act. Reverse engineering is a method of taking a device or program and taking it apart to determine how it works. Occasionally, in attempts to duplicate or improve it, generally this would be applied to devices or physical products that are protected by patents. However, in the realm of copyright, reverse engineering is allowed in some situations, specifically This applies to computer programs to allow interoperability of devices or systems. Since computer programs may be designed to only work with a few devices or systems, to allow a consumer to use them on another operating system, reverse engineering would be a necessity. This would allow individuals to ensure programs operate without interference or to add integration features. First, before reverse engineering the software, the individuals would have to satisfy a few requirements. For example, the software must have been legitimately acquired, used in good faith, and sole purpose of the action should be for identifying and analyzing the parts of the program needed for interoperability. Essentially, this allows white hat hacking and similar actions for the benefit of copyright holders and other interested parties. This is also the focus behind other white hat activities, such as bug bounties and other actions taken by people to improve security by hacking or finding exploits. The term open source refers to any program whose source code is made available for use or modification as users or other developers see fit. Unlike proprietary software, open source software is computer software that is developed as a public, open collaboration and made freely available to the public. Open source software is software with source code that anyone can inspect, modify, and enhance. Source code is the part of the software that most computer users don't ever see. It's the code computer programmers can manipulate to change how a piece of software, a program, or application works. Open source is a type of licensing agreement that allows users to freely modify a work, use said work in new ways, integrate the work into a larger project, or derive a new work based on the original. By removing barriers between innovators, open source promotes a free exchange of ideas within a community to derive creative, scientific, and technological advancements. The GNU General Public License is a series of widely used free software licenses that guarantee end users the four freedoms to run, study, share, and modify the software. Historically, the GPL license family has been one of the most popular software licenses in the free and open source software domain. Prominent free software programs licensed under the GPL include the Linux kernel and the GNU compiler collection.
Welcome to the last part of intellectual property discussion. This video presentation I will discuss competitive intelligence, trademark infringement, and cyber squatting. Competitive intelligence, gathering of legally obtainable information to help a company gain an advantage over rivals, often integrated into a company's strategic plans and decision making. Competitive intelligence is an act related to identifying, evaluating, and collecting patent and market data to know about your industry growth, competitors, and their strengths and weaknesses. It provides information about competitor plans, their product, and their next steps. Not the same as industrial espionage, which uses illegal means to obtain business information not available to the general public. Industrial espionage is the illegal and unethical theft of business trade secrets for use by a competitor to achieve a competitive advantage. It is often done by an insider or an employee who gains employment for the express purpose of spying and stealing information for a competitor. So without proper management safeguards, it can cross over to industrial espionage. So next is trademark infringement. Trademark infringement is the unauthorized use in a commerce of a registered trademark or a copy or colorable imitation thereof, which results in the likelihood of confusion among the consuming public. The most common type of intellectual property dispute is that of infringement. This is where intellectual property is used or appropriated without the owner's permission by another. Infringement can apply to many categories of intellectual property. Trademark is a logo, package design, phrase, sound, or word that enables consumer to differentiate one's company product from another's. One common example of trademark infringement is where clothing manufacturers attach brands label to generic items, attempting to have them as authentic. Trademark infringement violations are very serious and are often involve aspects of deceptive trade practices. So here are some examples of trademark trials. Facebook versus Teachbooks. Social networking site for teachers, Teachbooks, told a California judge that their name reflects teachers and books. Following a settlement with Facebook, Teachbooks now operates as TeachQuest. So next example is McDonald's versus McCurry. So McDonald's versus McCurry. In Malaysia, Indian restaurant McCurry said it named itself after Malaysian chicken curry. The appeal court said McDonald's could not claim an exclusive right to the MC prefix in the country. So then the last example, Apple Computers versus Apple Records. Between 1978 and 2006, trademark rights were wrestled between Apple Corps, owned by the Beatles, and Apple Computers, now Apple Incorporation. So the High Court of Justice ruled in favor of Apple Computer in 2006, before the companies reached a final settlement in 2007. So that's an example of trademark trials happen because of its similarities. And use or using of others' trademark in a website or other businesses can lead to issues. So best thing is to make sure that our personal brand of business is first and not a copy from other company. So the last topic is cyber squatting. Register domain names for famous trademarks or company names. The term cyber squatting refers to the unauthorized registration and use of internet domain names that are identical or similar trademarks, service marks, company names, or personal names. According to the Cybercrime Prevention Act of 2012, cybercrime is a acquisition of domain name over the internet in a bad faith or profit mislead, restore reputation, and deprive others from registering the same. If such domain name is similar identical or confusingly similar to an existing trademark registered with an appropriate government agency at the time of the domain name was registered. If it is identical or in any way similar with the name of a person other than the registrant, in this case a personal names, and lastly acquired without right or intellectual property interest in it. In a more understandable definition, we know that cyber pertains to digital or online, and squatting is an act of willingly occupying someone else's property without permission. So if you combine them together, cyber squatting is an act of digitally registering a domain name by taking someone else's property, such as famous trademark, without the permission of the owner. A cyber squatter will register a domain name, or also known as a web address, that is identical to known brand. In this way, they can gain profit from it. How? First, the domain squatters that purchase domain with the common words can put ads on the sites, in the hope that people searching the internet will land on the websites, and they will get paid for the page reviews. Other way of profiting from it is that they can sell the domain to trademark owners at a premium price. Other use of cyber squatting. Aside from gaining profit, the cyber squatter could use a domain in a bad faith by first, using the cyber squatted domain to spread malware or run phishing scams. Second, ruin a person or company's reputation. Third, take personal revenge. Fourth, they can even publish their extremist political, religious, or social beliefs. So always be informed, be aware of your rights, and be informed of cyber crimes and cyber criminals.